Okay, so it seems somewhat a bit more complicated in America because they've got all these different states and they've got governors and they've got these legislatures and senates, and it's split into three parts with their judicial, their executive, and the legislative. And they have different forms as well. But here, right, so in America, in the judicial branch, though, right, for state law, state judicial branches are usually led by the state Supreme Court, which hears appeals from lower-level state courts. Court structures and judicial appointments elections are determined by the legislation or the state constitution. Well, in America, there are a lot more elected people in America than there are in England. They must be having elections all the time, and the amount of forms they're filling in and boxes to tick with all these different people, it must be kind of like, no wonder they, we don't have that over here until we've started having these mayors, and we don't really vote for them that very often. In fact, I think we've only had one so far. What I'm starting to think at the moment is that with all these different variety in America and so forth, and then you've got all this corporate and companies who are starting to have their own policies, which aren't even law. They're meant to reflect the law. In fact, you would have thought if the laws are that different in America, then that's why you need complicated different company policies to reflect the different variations in law around America, particularly if you've got companies that, like Walmart, you've got a Walmart in different states, you've got different laws. That really is the essence of policy, so people know when they go in a shop or what they're doing, what the law is. It isn't really for these big companies they aren't the government. They aren't the government. They can make up certain rules and so forth. It's a private club, if you've got you have to wear certain clothes or dicky bow tie in nightclubs. If it's a private club for private members, but mainly when there's public access, the point in the policy really is meant to be, right? The point in the policy is meant to be so people are given notice of rule of law, and particularly companies have got certain laws, when you're allowed to return things and what your rights are, basically, particularly consumer rights and so forth. Now, the thing is that these massive companies, they've got so much money and they're getting bought out bigger and bigger and bigger and bigger companies, that they really are wanting to do what they want. And they're really kind of wanting the policies to be like law, like legislation, but it's not. They have to comply with the law, just like we do. And the thing is that a lot of them are lobbying the government and, bullying governments now, like Matt Kennard said, into, they're telling the government, so no, we're suing the governments if the government's, you're affecting our future profits. Yet where's all the suing for affecting the health of the nation, affecting the future health of the nation responsibility? Here, look, right, the Supreme Court focuses on correcting errors made in lower courts and therefore holds no trials. Well, that is very significant. This is different to England because you are actually, in England, you are getting a retrial or getting cases reheard or a different decision. It's not seen as correct. It's not seen as error correcting, mistake correcting. So they don't have any trials. Rulings made in state Supreme Courts are normally binding. However, when questions are raised regarding the consistency with the US Constitution, the US Constitution, matters may be appealed directly to the United States Supreme Court. Right, well, that's what I want to get onto. When the subject of the right to petition and petitioning, the law for petitioning itself is made up through the Constitution of the United States, through federal law. And if we can ascertain, which I've been trying to do, that there's a certain meaning and a certain interpretation, and there are certain things which that includes and what it meant, then that applies to all of the states of America. And, you know, if it's based on, and if it was meant to mean what the English Bill of Rights meant, then it essentially it's the same principles, the same meaning and the same interpretation, if we can agree on that the right to petition in the American government is there for the purpose and meaning of what it meant in the English historically, which is what we're trying to clarify. And therefore, if those meanings and interpretations of it are meant to apply to all of America, then the local states can't make up their own, you know, they can't change that law or make any laws in this legislative here. This legislative can't make any laws, because if Congress can't make any law, right, then, you know, if you can't be held to any commitments, how can, you know, how can they be making up laws around the rest of America? That's the whole point. Now, the thing that I wanted to draw attention to, therefore, is, you know, the fact that they've got all these elections going on. So there's a lot of elections going on in America. They're electing people for things. So there's a lot of electoral process going on. So really, there will be a lot more electoral process candidates and videos for elections on YouTube. There will be loads of them. Lots of them, because they're electing people all the time, this electoral process. But it includes petitioning the government. In fact, you only have elections. Elections only exist because we were petitioning these matters directly to the king, right? And then they decided to have people representing us. So you're personifying, you're giving orders to the person, you're giving instructions to the person like you give instructions to a lawyer. And that's why you have a person, and we even petition them to call Parliament together, right? So we can have someone going and representing us full time. Now, what happened is they started forming political parties and allegiances. This is all in the Peter Ackroyd book, Histories of England, Volume 3, when they started taking sides and wearing colours for parties and hanging around together, unlike Andrew Bridgen now, who sits by himself because they've all fallen out with him, right? Now, he's been, he's been cast out of his party, although he's still an MP. Andrew Bridgen is a perfect example. And he's always talking about representing his electorates. Now, so petitioning is, as the MPs discuss more and more matters of their own parties, and they believe that people are voting for them because of what their party's doing, they care less about people's petitions, even though people who didn't vote for their parties still have a right to petition because that party's not representing them. That's why they never voted for them. They'll have to do it themselves, and if you get a weight of signatures on those petitions, which is more than what one person got elected to represent everybody and all their concerns, you put in the power of signature and the people into one subject, which outweighs one person's entire elected term to represent all subjects. So these high numbers of signatures that these petition committee in Parliament are commanding, that you get even to debate it on one subject, is ludicrous. It's ridiculous. It's insulting. Now, you can actually petition your local council over matters. I don't know why they didn't ask the people of Wiltshire to have a referendum over the wanted Stonehenge tunnel or not. Interesting, because there's a certain classification of the land where the Stonehenge tunnel's going to go that's protected, and they've got to declassify it, and that actually comes down to the local people. I think Highways England, it could be a major trunk road that runs through it, but still, they refused to debate 15-minute city petitions in Parliament. They said, you go see local council about it, petition the local council. Why didn't they immediately say, about the Stonehenge Tunnel, it's Wiltshire. First, you'll have to go to the local council for petitions, and then, if you can't sort it out, then come to Parliament, right? Raise it, escalate it, right? But the matter of Stonehenge is not just about trunk roads. They could say it's Highways England, it's Department of Transport, therefore not the local council because it's a trunk road. But it also involves the status of the land all around it expanding out, which is not the Highways England or Department of Transport. So they should have actually referred it to Wiltshire Council, and the amount of signatures have got 200,000 is you can have a local referendum. It's massive, and they really don't want the people making decisions on matters in England. They don't like it. And you can have referendums to actually reform the entire council, or you can you can have a local referendums. You can do it. People don't bother using it because actually, and actually, anyone in England can sign. Wiltshire Council have admitted that if you've got an interest in the area or a business in the area, or, if you go through the area or use the facilities, or, clearly Stonehenge is a World Heritage Site, then you can petition. In England, you got the right, it's His Majesty's government, so, it's got the power and authority of the mace. It's the same mace. See, it's meant to be the same mace power. So, we can, and there should be. They make the local council petitions website really, really hard to sign it and log on and everything. It deters people. They don't really want those local signatures. Who would have an interest in the local area? Well, actually, if people started getting interested in the local area, people from all over England might want to support it. And then you'd be getting loads and loads of local referendums. In fact, with all these local Americans, these Americans are electing people left, right and centre. They're electing people like there's no tomorrow. There's so many elected positions. I never have a box through my letterbox to elect anyone except Tracy Brabin and a councillor every so often, or the, MP. That's it. In America, they've got loads of elected people. So why aren't we ticking more? We should be having loads and loads of referendums in England now that we've got the internet and people. If you can get people interested in it, or either work in the area, or even come through the ere, or even, right privilege and interest. You want to get them interested in the area, and if you've got ancient sites in the area that you want to get them interested in, but they've been decimated, destroyed, and covered up and hidden, then you're not going to get much interest at all. Stonehenge gets interest, but, when you don't see it anymore, there will be less interest. Maybe they should just scrap the road altogether and make them send the road somewhere, divert it somewhere nowhere near. How would that suit the Department of Transport? I think they're starting to wish they could have some sort of glass elevator now, like in Willy Wonka. But we should be having Parliament. Parliament and the Labour and Conservative don't want people to be having referendums because then. Firstly, it actually lets people realise that they can have them. And secondly, then people were doing what the people want to do on a particular matter, which might not be in line with what Labour or Conservative want. And they want to cast a big fishing net, so everyone votes for Labour or Tory, then we just go along with that. Yet there might be one big red herring in there, or a big whale caught in the net, which might be one matter, which might not be, people might not want to do what their party wanted to do, even if they voted for that party over the other parties, right? And they've got the right for referendum. So, Penny Mordaunt in Parliament and these other people, the Petitions Committee is scandalous. The Petitions Committee is scandalous. This Martin Day MP and this Keir Starmer ranking woman, this God knows, this deep-rooted Barry Shearman-esque Newcastle Geordie petitioner who hasn't got a clue about petitioning. She won't have a remote figment about petitioning other than she's in charge of it, and then she just does what she wants. And they cast off petitions pretending, we don't know what you're talking about. Well, you don't know what you're talking about when there's, only 50 words, and, you're using most of those up to justify that you can argue with them, debate that you can do it, and have it on legislation, and then when it comes down to what you actually want, now that you've actually debated that you can have it, what it is that you want, you've run out of characters. You know, so, you know, that Stonehenge Tunnel issue is big, and all these amalgamated petitions on that subject to His Majesty's government should be amalgamated in Wiltshire. And, you know, we should demolish the council and make them reform the council if they don't let us have it. And, you know, that land around Stonehenge, the status of the land, you know, that should be a big issue because it stretches into people's local area issues. It takes importance over trunk roads and so forth. So I think that the Parliament did it wrong. But yet, when Parliament, you know, oh no, you know, what they're doing is they're just making it up. You know, like with this 15-minute city, they could have devised a way of changing the laws so that, you know, it's very difficult or near impossible for local councils to have 15-minute cities unless they get approval from the people first, a certain amount or number of people. They can do that. Or make it so you have to have referendums about 15-minute cities. All you simply do is make an enactment or a statutory instrument saying that, okay, then all 15-minute cities can only be had by referendum. You know, how about that? You can have what you want in the law, right? But Parliament didn't want to entertain the idea. So they said, 15-minute cities aren't anything to do with government. You'll have to go see a local council. No! Did they say the 15-minute city in Wiltshire? Did they say the 15-minute city in Oxford? Did they say the 15-minute city here? No. They said all 15-minute cities, right? This is it. So that's one example, you know, when we should be having referendums in England, and that's something that's one case that I want to make to Wiltshire Council. I've got a petition on their website. I've asked them to amalgamate the other signatures, and I claim that I'm going to get a solicitor or lawyer to take them to magistrates' court and say that, you know, they're entitled to a referendum, and that Parliament have been rejecting other local matters. Parliament have been rejecting matters that people have brought nationally, 15-minute cities, and said, oh no, you know, we can't do anything about that. When they can, they're lacking creativity. They're lacking the will to find a way. No, there is a way. There are many, many ways. That's for Parliament to debate what the way is to do it. That people want. If you want a pair of shoes, right, to your cobbler, he makes them. You say, I want a pair of shoes. I want them red. I want them, you know, 6.5 size. Right? The Parliament, the shoe cobbler has to figure out how to make them. He's a cobbler. Right? This is the thing with Parliament. We want to stop 15-minute cities. Right? Or make them near impossible to have. Right? Parliament, you know, well, you debate how you're going to do it. We don't care how you're going to do it. We can have it. You know, we're not talking about this 15-minute city. We clearly said 15-minute cities. You know, this is the thing. So the importance of petitioning is very, very, very important. It predates, and it's there for even calling the Parliament to have the MPs. And really, you are petitioning for who's going to represent you in your petitions, really. You know, this is what the research says. And also, let's get on to, like, the subject of, you know, what does this petitioning mean in the law when they make it and so forth. You know, we've got all these laws that the Bill of Rights covers, like you can't have a standing army, you know, the right to bear arms for defence, but not attacking people. And then there's this other important part of the Bill of Rights, which says that you can't be charged for elections, you know, and petitions. You shouldn't be charged a fee. They should be free. Elections should be free, you know. You know, well, you can't have an election, you know, if you haven't been, you know, if you haven't got any matters to bring to your MP, any subjects to bring to your MP, like, you know, when you were bringing them by petition or even petitioning for a Parliament to be brought and having MPs. Now, what we found through the research is that they were charging people a fee, money. They were charging people to lay the petitions. I guess it's like, charging people. You don't get... The criminal cases come out of our tax money, but then obviously if you're convicted, you've got to pay this victim. The person who is found guilty actually pays the costs, don't they, and so forth. But notice that there is no fee to bring the case in the first place. It comes out of the taxpayers' money. Now, in civil cases, usually, although this is now started to fall into corruption, that guy who wanted to get all those documents off, that researcher who wanted to get documents off the royals, and then, where's the documents? So they've been destroyed. When did you destroy them? After you ask for them, he had difficulty clawing back monies in court fees. The person who wins the case doesn't pay the fee. The person who loses does. So that kind of suggests at least a recovery of funds, even if you can't afford. But how can you afford your lawyers? You got to pay for legal fees. Well, we have duty solicitors. So really, that law that law should be petitioning the government or bringing cases, at least by petition to Parliament. But there is even some, the existence of the duty solicitor is, it comes under the taxpayers' money, right? They're provided. So we're meant to have some form, you can get legal aid, they provide it. So they're kind of really saying, oh yeah, we fulfill that clause of the Bill of Rights, because, it is possible. Although I have never found it, and I've gone to pro boners, I've gone to, these voluntary, even in America, voluntary arts lawyers and so forth, and they never want to take the case on. It is very difficult. And I didn't have when I was in Shrewsbury, Telford, sorry. The day I was in, the duty solicitor wasn't there that day. How convenient! And that's the day when I had some very interesting material to for him to present for me. So. And with the elections, I've put this argument in another video for the Bill of Rights for elections should be free. Elections aren't really free, because if you look at some of the legislation for the processes and procedures, it says that only so much money can be spent. It can't cost over so much money, even to the council or to the government, which means there are costs. So it's not, the election isn't free. It's only that we aren't paying for it immediately. You don't turn up at the polling station and have to hand over £2.50. It appears free, right? But the costs are absorbed by the council for referendums once you get a referendum. But the petitioning is meant to be free. Maybe the state is meant to pay for the petitioning out of our local taxes, But then again, that would suggest, that would question political party donors. But at least what I'm saying is that for the polling station part of it, for the facilitation of it, the free facilitation, elections should be free, right? Which that isn't figuring in that, your political party sponsorship and donors aren't figured into that. That's all independent, right? This is for the facilitation of it. The facilitation of it isn't free, though, because, like I said before in another video, it comes out of his tax money, right? It comes out of the taxes. There is something to do with the ancient Irish law to do with, contribution and taxes. That's something to do with the law and how it's applied, and if you have to pay fines and so forth. There was some sort of insurance kind of based policy going on there, where we were insured for things. And if you were really naughty, you would get banished. And they had different laws in different villages. But this is what I've read recently anyway, in fact yesterday. So it isn't really free, because if it comes out of your tax money, then the election's not free. Now, we pay taxes for the roads being maintained, and for parks and so forth, all these things, right? And for the wages of the council staff. But it says that the election should be free. So they've got this thing where, it can't go over a certain amount, but there shouldn't be an amount. It really should all be voluntary for the elections. according to the Bill of Rights, if you interpret it properly, there's a strong case for the fact that, at least for the, there are volunteers who go sit there. I've seen volunteers in there, so that's free. And then if someone is going to donate their building, I'll let you use our building for it, like the local school or the polling station. Well, so a lot of the buildings are council owned anyway, right? So they're not going to charge themselves for use of the building. The promotional, so you've only got the promotional material and things like that. Now, the promotional material, like coming out of our council money because it's, printed off at the library and so forth. But who's supplying the paper? Is the paper supplied free? Is someone donating that? Or is it just figured in that, it's all tax money that is contributions. So at the end of the day, contributions are contributions, and they were charitable donations. So, it doesn't really matter whether it's a charitable piece of paper given or charitable money. It's interchangeable. I'll let them have that, right? But, there's some questions into this. But I think in the Bill of Rights, when it's saying these things like elections should be free, and I think it's going back to that Lord of the Articles and the whole thing when they were trying to charge them for bringing the petitions as well and so forth like that, because that fits it, which means they abolished the Lord of the Articles and they abolished these. They even got rid of this. I don't know if it's fully abolished yet because I haven't seen the actual copy because I haven't. I've only seen the Wikipedia copy and we've only had references to it. I haven't seen the complete Tumultuous Petitioning Act. I'd like to see which parts are repealed or if the whole thing's been repealed or not. But they don't have the 3 justices anymore or the grand jury to check the petitions or the London magistrates. That would be something if you had the London magistrates to check it, because then it wouldn't be going to the local courts. It wouldn't be going to the you wouldn't be able to have it heard in your local courts. It would have to be the London magistrates, not in your local area, which brings it more towards Parliament and in London and the Palace of Westminster, the whole thing, at least for petitioning the government, for laws being made or changed, or for public inquiries and things like that. So, this, I strongly believe that it means all those ridiculous rules and procedures around petitioning, right? And being charged for it. That's why I think that it's also, these are being held to commitments, being held to the commitments and, illegal prosecutions by the King's Bench, but through the courts, because you're bringing a case to the Palace of Westminster, So, so in America at the moment, they're doing these petitioning for referendum in Atlanta, in Georgia, and they've got these ridiculous rules they're making them do. But this is not even the referendum. This is not even the public-funded, facilitated referendum, when they make sure everyone gets a notice through their letterbox about it, maybe even with a number on it, a serial number, like we get for voting, and then turn up at the polling station and then mark you off. This is just the petition for it, getting enough signatures. Right? But they're making them say, oh, you've got to have witnesses, this and that, you've got these time limits and so forth. All that's tosh. You can't be held to commitment, and that's federal law, and I think that's what it means and should apply to all states and in England. Now, the only thing that you do need is something that needs to be written down, or either voiced, written down. You used to be able to give petitions verbally, and they got written down and passed on. That's in the Karen Bowie paper. It says that. But obviously, if you go see your MP at your surgery over a matter that you want him to, you'd like him to, do in Parliament, whether you bring loads of signatures with you or whether you just see him about it yourself, whether you can do anything about it, that's verbally, right? So when you write it down, you're writing what it is, what you're asking. And if anyone signs it, they're signing their name. And obviously, if you can't identify them, then, there is this legitimacy in legitimising witnesses. So, now the thing with America is at the moment they're saying, no, it's got to have this, it's got to have that on it. Well, the signature, the thing is, right, all this witness for the signature, I think, is a bit toshish, because at the end of the day, right, why do you need the name on and the address? Not only to say, here I am, I've signed it, and, sign it to make it official, sign it, right? You don't need a witness when you're filling in any fines to the government. You don't need a witness, when you get a letter through saying that you got a parking ticket. When you fill it in your house, you don't need a witness. That's a legitimate legal process for government. These American laws are ridiculous. And also another main thing is this. So, it's not just to say who you are and that you support it. The authority that we pay our taxes to fund, when, you hand them in, if they question, your position in them, you're trying the information. All right, we're going to have a try with the council to say we want a referendum. If the council doubt the information, right, I beg your pardon, then they can check it. Why is everyone's name on there and address? So they can check, so they can contact them. You don't need a witness, because if a person signed it and the signature's there, and if you doubt that signature is authentic and no one witnessed it, then you check the address, you check it on the state system or whatever, and you ring them up or write to them or telephone them to ask them to confirm and verify it, right? That's it. Now, that might cost a lot of money or whatever, but, these people are going about their best efforts. I don't think it's legally binding that they've got to jump through all these hoops and do all these ridiculous processes and procedures. Yes, it's going to make it a lot easier for the council to check it, but what do they pay the taxes for? The other question in America is the fact that all states have got different laws, but there's one petition law meant to be federal right. Yeah, that's the whole point of it, for how they can elect people locally and so forth. In England, I've just mentioned this about Stonehenge and Wiltshire Council, and Wiltshire Council admit that, if you own a business in the area or you use the facilities or you have that basically means if you've got an interest in the area, if it's an ancient site of World Heritage and you go there for festivals, then you've got an interest in it, or if you just like it. In England, it's His Majesty's local council, and it is the same authority in Mace. They can't stop you signing petitions. The referendums, when you get the referendum, it's different. The referendum is a thing, right? It does something. It's like a device, right? You get every single person in that area, and you ask them what their opinion is. Like, if you get like one of those big fat LED torches that have loads of LED lights in, and you switch it on, they all light up, right? So if they all light up, red or blue or whatever, or yellow or orange, you count how many yellow ones are and how many orange ones they are. It switch it on and off. It's got a fixed number of LED bulbs in the torch, right? And, if you switch it on, the torch is on. Now, what you do when you have the referendum is you ask every single person what they think about a matter, and they all light up. And the ones that don't light up, don't have an opinion, and you count all the opinions either way. It's fixed. But that is the referendum. It's a thing. So that LED torch, that thing, right? What can I do I want one of those. I want a referendum in Wiltshire. I want the people in Wiltshire to vote on something. What's the price? What does it cost? Can I have it? What's the price tag on the LED torch on the referendum? I'm not doubting that the referendum is every single person within an area, like the area in the torch, every single LED bulb that's fitted to it, right? But I believe that anyone can buy that. but not like political parties buying people, swaying their opinion or whatever, the local council swaying their opinion, or, sold out, or, this whole blackmail or whatever principle. I'm talking about what does it cost? Our election should be free. It shouldn't cost anything. But what I mean to say is, can the people of England, with their right to petition His Majesty's government and the King, and it's His Majesty's local council only has the authority of the King, in Wiltshire, that trigger button, to pull the trigger button on the torch to get all the LED lights to light up to whichever, colour they want, whether it was, red or yellow or whatever, right, for what their opinion is. To pull that trigger on the torch, I believe that you have to have the weight of, this equal to 5% of the electorate of what that, torch is, to show that the strength of the opinion matches, 5% of the electorate. That's what I think, and how I think it should be. And that those petitions, you can have people from the local area, but it concerns people. You see, some people work within that area, but don't live there. So they don't have they're within the area of that, this hypothetical torch, like this, these multiple LED lights in a circle. Like if you've got a business in that area, or you like it, or you go there, but you don't actually, not a registered voter there, like an LED bulb there, but, you're still a subject of the realm. If we can collect, 26,000 signatures, legitimate, from English people, including some people in Wiltshire or some people out of Wiltshire, there's enough strength in numbers to pull, the 5% equal, to the weight of the torch, then that should trigger the referendum. I'm not saying that people, who aren't registered to vote in Wiltshire, should vote in the referendum, because it is a thing. But we're talking about the trigger weight, and it matters to, it matters to many people in England. It matters to them. That's what I'm saying. And I think that is, we have got the right to that, because of the fact that it's all councils are His Majesty's government, right? But a referendum is a thing. But you're petitioning for the referendum. You're not referendum. You're not having a referendum for a referendum. It's called petition for a referendum. So therefore, if it is called, if you can you can petition for what you want. I think that's what it comes down to, right? Anyone in England can petition His Majesty's government for the King for whatever they want. And if they want the people in Wiltshire to have a referendum, then they can petition His Majesty's government for a referendum in Wiltshire. I think that's it. And this whole Parliament debating it, why didn't they give him a referendum in Wiltshire when there's 200,000 signatures? Why did they say 15-minute cities, go see Oxford Council? Well, there's a tunnel in Stonehenge affecting loads of the land. Oh, you'll have to go see Wiltshire Council about it. Oh, well, that's good. That's good because we've got 200,000 signatures, well over what you need to have a referendum in Wiltshire on it. This is it. And if they're going to try and say that, you can only have a referendum about stripping the council down. Well, maybe we need to strip the council down. Take the stones off the top of it. Like on Stonehenge. There's already been a court case by Rollo Morgfling. To stop that tunnel. It's going to. The thing with the Celtic religion is it was all symbolic, the landscape and the shape and form of the land. And I think that making a huge hole into the landscape there is really like screwing it, basically, and the whole energy of it. And I think the archaeologists mainly might like to have I think the part of it might be that they might want to have, it gives them a good excuse to have a good deep dig around under the ground. But again, this is the problem with archaeologists. there's a lot of religious sites that have got meant to have European Union religious protection, and I don't think that a lot of those sites should have got permission. But, we're going into that now. But, as for it, definitely in the Bill of Rights, it talks about elections should be free, right? Which means that you're not to be held to any commitments or shouldn't be charged a fee for them, right? So I don't think that, I don't think that all these ridiculous rules are allowed, because all you need is the signature, and you need to know who's signing and what the subject is. It's pretty simple, and then you can check whether they do support it or not, particularly in modern times. And I think that's what it means, and therefore I think that's what the American bill means, and Congress shall make no law. It's like, because you can't be charging people for petitioning. That would be an example. Elections should be free. And that's what it should mean for the whole of America. So I don't think that these Atlanta laws, all these ridiculous rules that are meant to be like some of the most stringent in America are legitimate. It's a straightforward process. Obviously, you don't want any fraud, but what about any legal process, any letter, any business? There's all kinds of things going on, people buying and selling. This is it. So it comes down to the interpretation, and you've got to get the interpretation corrected. You have to do the history, you have to do the research, and you have to try and find out what was originally intended and why it was originally intended. To know what it means now, and to find out if it's been perverted or, in some way undermined. And there's a lot of people now want to undermine these processes, mainly big corporate companies who want to have things their way and are making so much money they're buying up more companies. And then they're making these policies. I think in America, once you start owning different companies and there's look at this, there's all these different rules I've got to abide by through America, all these different state laws, but I've got a McDonald's in every state, but there's loads of slightly different laws, right? What they're thinking is, well, I've got my own slightly different company. Some people's companies are bigger than some states. Like BlackRock Vanguard. And I think when they're making companies, they're setting all these policies, right? And they're kind of like thinking, private clubs have rules, right? But it's not the law. It's not the law. You just get kicked out of the club, right? You can have civil cases against each other, but that this tort law, whatever it's called, or this, between party A and party B, civil cases, someone owes someone else some money. This is the thing with theft. It's illegal to steal something, right? That is theft. But when it comes down to civil cases, if you split up with a partner and she's got some money and you don't, and you go, to the courts to say you owe money, why aren't you prosecuting her criminally for theft? Then she gets a conviction and goes to court. But that isn't recovering money, is it? Criminal cases don't make people, hand things over, or, the rights to land. And so whose land is this, right? They secure a conviction. It says, you are naughty and you have to be punished. That doesn't requisition things, does it? It doesn't get things back. This is civil cases, right? So what? Why doesn't every husband who split up with his wife prosecute her for theft when she takes her things? Why do we do these civil cases to, they usually say they're a criminal if they're fighting, clawing each other, slapping each other around the face. For land acquisitions, husband split up with his wife. We don't say, he stole the land, we're going to prosecute him. They say who's got the right to the land, who are the judges going to give it to? If in the civil court, right? Now really, I kind of want to. I've got to do this claim with YouTube, right? Because they're taking all our videos down, and the thing is this, right? They're taking people's channels and videos down, and they've got these policies, and they're throwing these policies around now as if it is the law of the country. but it's not the law of the country. Really, what you're allowed to do and not allowed to do, right, by making videos or even doing stuff is what the law of the country says. You know, if you're making a movie, you aren't really going to punch someone. It's acting. If you're making a movie, you aren't really going to smash a car up, someone's car. It's pretend. Or you buy a old car. It's staged, fake, So you've got this thing between pretend or real, right? But then you've got to take into account, right, this certification, the age, right? Because even if it's pretend, even if it's not real, right? And you aren't breaking, if you're really punching someone or if you're really smashing their car up, right? So that's illegal. There are crimes for that. You can't do it anyway. You don't need any YouTube policy. It's illegal, right? So what happens is, like, it's a fictional program. It's pretend, it's staged. It didn't really happen. It's made to look like that, or we, bought. It's my property. It's not someone else's car, right? But you still can't show that. Even though you can do it, you can film it and make it, right? People can't watch it or see it because it looks like the real thing. It's made to look like it, so it might scare someone or upset them. These are dangerous, illegal, or harmful acts, right? That's why you have a certification. Now, YouTube luckily have a 18 thing now, right? Which says, you can set it to adult only. Only adults can watch it. Oh, that's convenient. That means that surely can it have... why would it have an adult setting? What's the point? Why would you have an adult setting? You don't have it for nothing. You don't set the adult setting for no reason. You don't set the adult setting so... it's for something. So what is that something that would be adult? Well, surely it is only something that might be in a movie that's certified. So it's something that looks like, appears like, or poses as a sex or harmful, dangerous, or illegal act. Right? That's why you set your 18 certificate, which they've got on YouTube now. You don't have it if you're not going to use it. So the only thing is that if it's acted and not real, then that's why YouTube are even showing films that are certified and even letting you rent them out. There's 007 on there getting his balls bashed. Harmful, dangerous acts. Many films have sex scenes. YouTube rent these films out, right? And then you've got political rights. Now, if it really happened, if it is not an enactment, if it is not stage, pretend, a play, then it was illegal. So this is where YouTube's policy comes in, because if it actually isn't pretend and not for over 18, if it broke the law, then it was an illegal act, or it harmed someone, or could, we don't want people to get those ideas to do that, dangerous, try and getting people to, walk on the edge of cliffs or something like that. But it's real, not pretend. Is that dangerous? Should you be able to have extreme sports and cliff walking? And then you've got, harmful, self-harm, people like cutting their own, self-harming themselves, right? Not acting. Now, the thing is, all those things appear in films, but it gets a certification. That's why it's over 18, or swearing. The only reason the 18 certificate exists is so you can have it, but only over a certain age, right? When it's not acted, when it's not pretend, then it's illegal or harmful or dangerous. But the thing is, they shouldn't really be being seen by young people anyway, even if it's only pretend. Now, the thing with YouTube is that there are loads and loads of sexual things all over YouTube, like that Flexisex album, for example. And now they've got all these ASMR, which people are using fetishes for sex. Right? I uploaded a video I didn't even upload it publicly, so it didn't put anyone at risk, right? I shared it with one person. It was link only, which is the equivalent of sending a letter or message. It's not the equivalent of publishing. To publish something, it needs to be accessible by people, right? If you send one copy of it or a personal private message of something, it's regarded as a letter or you're sending someone a letter or a private communication. It's not being published. It's being sent as a letter, like you sent through a letterbox. So YouTube are in breach of their policy because they're trying to get you. They've got these settings like, publish it or link share only or completely private. And what they're doing is they're completely banning you from the platform, even if it breaks their policy, even if it's private or link only, right? Well, that's actually not legally regarded as publishing, in my view, because it's if you can only share the link with a selected person or people, then you're sending a letter, and that's like Royal Mail or private communication. It's not actually publishing, and there are certain laws over sending people a letter, a personal communication or private message, right? So YouTube are warping that. They're trying to ban you on their policy and say they're trying to make out that everything that you do on there is regarded as publishing when it's not. So that's the first thing that Google and Alphabet and BlackRock Vanguard, who are puppeting them, are trying to do. The other thing is this discrepancy between real or pretend, right? Pretend, it doesn't break the law. As long as because you didn't really do the act, but to watch it, because it's frightening or bad influence or whatever, you can only watch it over a certain age. But YouTube currently, I haven't actually done any act in real life. I haven't done any violent, dangerous, or harmful act in real life at all, and I haven't really used any material of it anyway. So I can't possibly have violated the serious policy anyway. The serious policy gets your channel taken down straight away, even if you've got no strikes, right? Now, the thing is, they've got violent and dangerous acts all over YouTube, but they're regarded as pretend, which is why you've got 18 certification, right? So all my videos really should be on over 18. Right, I can't have my channel taken down because I hadn't actually put any violent or dangerous acts. Now, they've got normal, regular strikes, which aren't violent, dangerous, or illegal. And it clearly states the sexual content is not even mentioned in violent, dangerous, or illegal at all. So you can't. There is normal strikes, things that they're saying they don't allow, but it's not serious, right? Like they're saying they don't want sexual on there. Now, the thing with the sexual one is it's not violent, dangerous, or illegal. So you can't have a serious strike for it unless it is sexual acts that have violent, dangerous, or illegal things in it. The Sexual Policy Act itself alone, just regular, and they're allowing fetish on there, remember, and they've got that flexi-sex which they refuse to take down, The thing is, right, with the sexual acts, right, you can have acting or real, pretend or real, but the thing is their sexual policy says they don't allow anything that's sexual at all that you could get sexual gratification from, right? Because you could get sexual gratification from something, whether it's pretend or real, right? Unlike the dangerous acts, like on the 007 films, where it's all pretend. If it were real, then it would be actually illegal. With the sexual things, it is not, even if if it's real or pretend, it doesn't matter as long as it's not dangerous, violent, or illegal. Sexual acts, right? Or unless you're under a certain age, it's illegal. But sexual acts are legal. They're actually legal. So YouTube's saying that they don't allow any, sexual acts at all, or anything you could even get sexual gratification from. That would be kissing. That would include kissing. But really, it's so loose terms, but then there's all this, people are actually getting sexual gratification from all this ASMR stuff, right? So what YouTube have done now, because that would be violating their policy on what they say, if people are, in fact, if you show evidence of people getting sexual gratification from it, you could send it in and take them to court, right? So they're calling it fetish stuff now, and they're saying, oh, that's not sexual, it's fetish, right? So again, more loose terms. So they've got these very, very vague terms. But the policy anyway is not even... Some of their... what they're trying to do is... because there's so many different laws in different states, and because they've got so much money, and because they... it's not a private club, by the way. Anyone can go on there and view it with free internet connection, library, and without an account, without having an account, anyone can read the comments and watch the videos, be spoken to, and be addressed by, it's definitely not private. It's publicly accessible, like a shop you can walk into and look around it and ask how much things are, or look at shoes and not buy them, then walk out. It's publicly accessible. So you should be able to have free speech on there. It's not a private club, that's for sure. It's absolutely not a private members only club. They're trying to turn it into it because they've got all these new join things popping up. First, they want you to subscribe and get everyone to subscribe. Now they're having join. I think they want to make it so it's members only. You've got to join. But at the moment, it's public access. This is the way they're trying to push it all. So now this is the problem. If all of YouTube's policy was merely there to reflect and remind you of state and federal law, there wouldn't be a problem, because you'd be breaking, if you didn't comply with the policy, you'd be breaking the law, right? You'd be breaking the law. But there are different laws in different states, and then there's federal law, right? Now, it complicates it when they want to start messing around having policy which is not necessarily the law. They just don't want you to do things because it's actually not illegal, right? They're just, but you don't have to be a member to go on there to read it or watch it, right? But you have to have an account to upload stuff, to publish. But private link share isn't publishing, I don't think. If you're only, depending on who you send it to, there's serious legal issues with that. Because if you send a link to one person, that's like sending them a letter. That's not publishing it. It's only accessible by the link. That's like only reading a letter if someone gives you it, reads you it, So with the policy, right? Let's get into the legislation part of it, right? So the only real area that we're concerned about really is the area of their policy which isn't illegal for us, but they don't want us to they're trying to stop us from doing it, right? So that's when you get into, their policy and what does it say? Well, the thing is, they're saying that you can't have any harmful or dangerous acts on there, but it doesn't say whether they're pretend or real. That's one thing for starters. Because anything you watch that's harmful or dangerous, people can be influenced by it. So how can you have 007 on there and even rent 007 films out, even over 18, if they say they don't allow any harmful or dangerous acts to be shown at all? What they're saying is they do allow harmful or dangerous acts, videos of them, only if it's pretend, right? But they don't make that clear. Particularly, obviously, if it's over 18, then that's where all these movies come in, over 18. And I've never actually uploaded anything that is real whatsoever. It'd have to be live footage. It'd have to be live, real footage, right? Real, actual footage that is live. But all my footage is either from film examples or cartoons, or from, like I made it up, like I've collaged it. So none of it, I didn't film. The only thing that I film is recording my voice, and that's free speech, and that's when we're getting onto free speech. But, I don't really upload any videos of me doing anything, or I don't film anybody really that much, mainly just talking now, right? So you know, most people now, you know, a lot of it's, you know, regurgitating or editing or modifying stuff which is going into copyright. So their policy says, though, that they will comply with and abide by and apply state and federal law. So they have got to obey the law and comply with the law, as well as us. So they're saying that, you know, we're not allowed to put any dangerous or illegal or harmful acts. You know, that suggests that, you know, acts might not be illegal if it's dangerous or harmful, because then it could be pretend, you know. But then again, you've got, self-harm and all things like that, you know. But so what does this entail, them complying with the law? Well, they're not allowed to refuse your rights, because that's what the law is. So then we're arguing on, you know, where do these rights apply and where don't they apply, right? Well, the law itself applies sometimes differently in public to private, like, you know, even racism. The last time I read one of the acts for racism, it said, and I don't know if it was the latest revision of it, but it said that racism is only illegal discrimination in public, which means not in a private house, which, you know, means that, if you wanted to, Nigel Farage, you could say, I only want Chinese people in this house or whatever, right? You know, something like that, right? And it not be actually illegal or discriminative because it's your house, right? With private businesses and so forth, we start to change. So the law is different, private and public, but then you've got places that are public access, like libraries and so forth, right? So you've got like completely private, then you've got public places like libraries and the plaza, and then you've got completely private houses or private clubs, right? Now with YouTube, it's not completely private. It isn't a private club, and it isn't member only, because you can read comments and watch videos without logging in, right? That's for starters. So it isn't private. It's publicly accessible, right? So what does this what do the rights mean, and where do the rights apply? Well, that's where we get into his argument about the rights, the right to petition, and all prosecutions and commitments for doing so are illegal or being imprisoned. So one thing's for sure, if your free speech is free speech, and that's a separate clause, and the petition goes further than free speech, it's separate. If it was just free speech, then you wouldn't need it. It has to do something extra, and it has to go further than just free speech, right? You know, or else it would just be the right of you to speak freely to Parliament, or right, sometimes those petitions were given verbally, like to your MP, and so forth, into your MP surgery, speak freely. Why isn't it just free speech to your MP? Why do you need the right to petition, and all prosecutions and criminals in doing so are illegal? If you already got the right to speak freely, why would it be illegal to speak? And they didn't have all these complicated harassment and intimidation or discrimination laws back then. It's questionable if some of these harassment and discrimination laws are actually, they themselves, those laws have hacked into the free speech, because back then you didn't have all those exotic laws. It completely and totally protected speaking freely, right? Which is, or at least if you're petitioning, well, you've got free speech when you're not petitioning, and if you've got petitioning, so petitioning surely should protect us from all these new laws that are coming in that are making it illegal. Well, that would make sense to say that all prosecutions are illegal, because if you've got free speech it's not illegal, why would anyone be prosecuting you? It's a complete and total no-brainer, right? So it has to protect you against things that might have been illegal. Now, we know that, charging for petitions, or even just, the actual petition in itself wasn't illegal, and it also didn't invent it in the act. But they were making up charges or just trying people for various things, right? It mainly, the main issue around petition, what are the things that we're doing, what we're going to do for this petition, mainly is speaking, writing, giving notice, promoting it, and sending it and submitting it. Also, there is an element of judicial. Like in these state laws, you've got the executive branch, the legislative branch, and the judicial branch. With petitioning, you've got these matters, there are legal judicial matters. They're trying to say that you can't petition about those to the government, to the highest now, but you can, and you could, even for pardons and so forth. You just don't want to, or you can't about MPs. Complaints to the local council monitoring officer with several witnesses signing it and giving evidence testimony and signing it, 20 of them, is petition to the local council with grievance over a councillor. I can tell you that. Doesn't matter whether the monitoring officer deals with it or the Scarlet Pimpernel. It's petitioning the local council over grievance over a councillor. That's what it is, right? So there's this investigative thing. The thing with the petitions is the number of signatories is not just how important it is, but it is witness. It's not just like it's got it. The fundamental, this thing that we've definitely got that predates electing MPs and predates calling the Parliament, which is getting matters resolved to the monarch or through the Parliament when you've got it. It is a proceeding, a judicial process, and we've had judicial people involved in it, and then been removed or added or removed, right? It is a judicial process. Therefore, the nature of bringing it, whether it's a person or a number of people, it has these factors involved. Firstly, you're bringing a subject, a topic, a matter, and you're communicating a request for something, whatever that request is, right? And, you've got... Like in elections, how many people isn't important to? If you've only got a village with 3 people, right, and you all vote, right, it's usually either no votes, 1 vote, 2 votes, or all in favour, right? You can either only have 3 votes, 2 votes, or 1 vote, right? That is either all... You can only have... you've either got a minority, that's 1 against 2. You've either got a majority, that's 2 against 1, or you've either got all in favour or none in favour, right? If you break it down to 3 persons to the triangle, right, none of them vote for it, so you don't even raise the subject, or if you don't even raise the subject, it could be the same. It could be the same as all being opposed to it. If none of them raise it, or it not even being relevant at all, right? So there's this element of voting because with anything, you have to have to raise the topic. One person has to be in favour of a topic, and the topic has to exist, right? And then whether the subject or the topic itself is true or not. So there are these fundamental factors in the subject, bringing the subject, which is who is bringing it and how many people are bringing it, and what the strength of the number of people who support it. But then you've got, is it true or not? But obviously, if a lot of people support it, it's unlikely not to be. So therefore, evidence comes as part of it. There's this, to raise the topic or bring the topic, you're justifying it, evidence of truth and support. So they're all linked in together fundamentally, because I like the example of a brand new invention, right? I like this. I like the example of a brand new invention. It's like if a scientist invents something, like a device, because the device is evidence that the device exists, right? And it does something, and you might be asking for some law around it to legislate on it, right? And so you've got all these, people who want to use it, people who like it, or people opposed to it, and then you want to know who those people are and check who those people are. But checking and verifying the people is only as important as checking and verifying the subject. So the evidence to prove the subject is like the signatures. You can write your name down but not sign it, but your signature is meant to prove who you are because you've got a unique signature verification. And then, then Parliament, contact you to verify that. Hello, Mr. Smith, is this your signature? I'm able to contact you conveniently because your address is on here, right? What coincidence, here's the professor's invention. We've got some evidence that it's going to be any good to anyone, right? So investigative functions, this is expressed through the judicial procedure anyway. Now, the only difference between the judicial procedure is what you're asking for, because, with the criminal justice, you're asking for the punishment of a person or people, right? And like I said, with the civil process, you're asking for the ownership of something to be confirmed, to be proved, and an exchange in money, finances, or ownership, titles, privileges, right? To verify it, to check it. And then with Parliament, you are wanting to get the very laws made or changed, or them to do something that it's their responsibility to do, or hold an inquiry or something, over something important, right? So all of those processes and procedures, the petition to Parliament is a judicial process, right? And I don't know any court case where you need a witness to watch you sign it, because that's submitting the documents, isn't it? And it's not the actual referendum itself. It's not the actual court case. Petitioning the government is gathering the witness signatures. You are the witness. The thing is, each person is the witness. You don't witness a witness. And that's the insane thing about this Atlanta thing, right? You don't witness a witness. Because in a court case, when you submit a statement, you are a witness. You are the new witness, right? You don't need someone to witness the witness. When you send in to the police, they don't say, did someone watch you write your statement? That's ridiculous. A policeman can come around to your house and ask you to write it, or they can write you a letter. But if you would need a witness to witness the witness, just sending in their statement to say, I support this, which the council has the right and privilege to check and verify, as long as you've got the full information down. You don't have a witness witnessing a witness. Usually you're trying to find witnesses who did witness it, but not for each individual statement. It's for the jury. Once you get into the courtroom, once you get the proceedings going, that's why you're assembled there, to look at everything and decide whether it is legitimate or not. If it had already, by the time the Americans are finished, you're at someone's house and you need a witness to witness the witness. You can't just publish it in the newspaper and then sign it and send it in, right? That's the level, and the integrity and level of the actual referendum itself is of a different level, because you've obtained what you're petitioning for, or they've looked at the evidence. Because with the referendum, then it's officially going to take place like in the local elections, and surely then the taxpayer pays for every single person is sent a notice and they can turn up and vote. That is it. Now, in a polling station, it's true that you've got those people sat there and they watch you go into the booth, but you kind of like disappear into the booth because it's sort of private, and all you do is tick a box. When you actually get, past all the notices through the letterbox and past all the petition signing, when you get to the nitty-gritty of elections, when you actually get to the polling station and get into the booth and there's a scrap of paper there and it's got 3 names and 3 boxes and all it says is the name of the person and their party and a box, you're actually even putting a cross or a tick in there. And you're not even putting your name or address on there. So God knows whose it is that there is a vote for this or there's a vote for that. You're actually going to a more reductive, you're reducing the process, So I don't know how the American government in these the petition for the referendum, not even the actual referendum, I don't know why they're saying you've got a witness to witness the witness. Because that is insulting to when you degrade it into a polling booth when it's just ticking a box and you're not even verifying who you are on that piece of paper and signing it or putting your address. Apparently they've already verified that as long as you're there now. You mark it on the thing. Maybe what that would do is solve all the problem of spoiled ballots. Because then there would be no ballot set aside. You would actually say, just a minute, I'm not too sure what this mark is on here. It's Mr. Johnson. I'll ring him up. Mr. Johnson, we've got a problem with your ballot paper. It's, spoiled. Could you confirm who you voted for, please? Yes, I'm sorry. It was, no, actually, I spoiled this on purpose. Yeah, well, why did you turn up then? No, I'm just waiting you a phone call, This is it. That maybe the political parties like it when some gets set aside, Maybe they like the fact that it doesn't have each name on it and they don't have to ring them up and confirm them. Maybe that would clarify a lot of the, if there was any cheating going on in the past in elections. Now they've got you to turn up with the ID. To be honest, the digital ID when you turn up there is joke. It's almost like having, it's almost like having a security guard at an army base who checks you to see if you've got any guns or knives or bombs, and then when you walk in and get through the gate, then you walk into a room and there's a pile of fucking hand grenades in there, and you just pull the fucking pin out of one of them and blow the whole fucking thing up, That is how Tony Blair and, effectively, I think this is how they've been cheating all these years. Charles and the Queen and all these, other people. That's it. I mean, it's like the maximum security prison until you get inside and there's a pile of hand grenades and weapons in there. So, all the criminal... It's like you blow, it's like, what's in that? It's like having a safe. When you get, it's like opening, it's like on Goldfinger. It's like on Goldfinger, isn't it? When there's all that army base and then they get past all the soldiers and then they get in there and then they laser the door down and then there's a vault and then he's got to look through those goggle screens at the thing and then he opens it and then they've got to go down on the elevator and then he takes a bomb in there to blow it up and then he's going to make it all radioactive so all the gold's lost its value or something and their value goes up. It's like that. I haven't really realised that before. Well, I always thought the ballot paper was a bit flimsy, but there's this thing to do with, they don't want to identify you, they don't want to know who you are, or because your political opinion's private. It's not private when you're Richard Tice. It's not private when you're, these politically disclosed people like Nigel Farage or whatsoever, but... disclosed to who, the council or the counters or whatever, but many people are politically exposed or choose, but that's why you've got the right to petition. So you can, at least, if people don't want to hang around with you socially because you're a Labour or Lib Dem or thing, at least legally they can't deny you a bank account or they can't refuse you service in a shop. That's meant to be what the law is. So they can't discriminate against you, refuse service or discriminate against you because of your political opinion. And that's meant to be what the right to petition is. So, prosecutions are illegal, fines and, civil cases and so forth, and being treated differently because of that's meant to be that what these people are promoting, everyone being treated equal, this new politically exposed stunt with the banks, I've just kind of figured it all out now. And actually, the digital ID that they've just introduced, so when you turn up and prove who you are, there was only meant to print out one thing anyway. Out of all the people who did vote, if you went and voted and if you turned up at the polling station and, your name's been scribbled out like you've already been, then it's clear that, someone's already been and tried to vote as you, unless the person didn't cross it out. So I don't think the digital ID or having to take ID was a total. It's a red herring. It's total rubbish. It only matters to the unknown amount of people who don't vote, because you could then once it's over and all people didn't turn up, you could kind of scribble their name off and say they did turn up, and then just fill a couple of tickets in and stick them in the box because you don't know who they are on the thing, right? It only really mattered concerning the amount of people who didn't vote, because that was the portion, that was the section of people who that could have been taken advantage of, right? And used. But I don't think it solves the problem, because at the end of the day, right, why have all these witnesses, in America, witnesses needing witnesses for petitions and then so forth, and then, these procedures and all these complicated rules, when you get into the ballot box, it's just like a box and you just tick it and there's nothing else written on it, because, you can't really... You can count them, you can count the numbers, but even if you were checked on the door, it's still open for manipulation, because you still can't ask. And I really think that those spoiled ballots really void the whole thing, because if you're making people prove they have digital ID before they cast their vote, then you've got no excuse for not knowing what someone's opinion are or who they are. And that's why... It's like it's more important to the government that they know who you are than what your political opinion is, because they're not actually attaching who you are to your mark on the paper at the end of the day when the evidence is there. I mean, they might say, well, there's 100 votes in this box and there's 100 people here, but then you've got those ones that are unmarked, spoiled, right? And the elections still are counted. And this is now taking me into 38 degrees, which is my other complaint, right? Because I've got a complaint against YouTube, right, for breach of political rights. And then there's the whole YouTube thing. Oh, sorry, the 38 degrees thing, right? There's a YouTube thing with the political rights and copyright, and then there's 38 degrees. And 38 degrees, firstly, they weren't giving over the email addresses to everyone that they'd collected. They were saying, oh, it's data protection, we've got to keep them. Well, it's my petition. I created it. I drafted it. My name is the creator, and I have the data rights to that document, and I collected the signatures, but you weren't giving me over the emails. And then you were complaining that the emails, some of them aren't legitimate. And then instead of just taking them off or setting them aside, right, you took the petitions down, when that's a legal case that I'm running to the government, which I've got a right to do without intervention, like illegal campaign intervention, 5013C, that's intervening in someone's casework. And now that we know through the research that it is a proper judicial process, a third party can't intervene in it or take it down. And they are not responsible for counting the signatures and verifying them. The council are. The person who creates it can, but, and a petition doesn't have to be judged only on the signatures or number of people who support it. It can be decided on merit of the evidence or casework, and my petitions has a lot of casework and videos and material attached. And that's why in the local councils don't necessarily need lots of signatures to get it actioned. You need a lot for a referendum, but you don't need a lot to get it actioned. You can get it actioned with a lot less signatures. This is the thing. With Parliament, they're asking for 100,000 signatures, but, you only need 26,000 in the local area for a referendum. And you can get it actioned on a lot less. So... 38 Degrees, I don't think they have got the right, and they can't write it into their policy to have the right to take it down, because it's a judicial legal process between the person who drafts it and the recipient who it's addressed to, which either is a local council, authority, chamber or parliament. And 38 Degrees are just a facilitator, right? If they want to have a petition site like 38 Degrees, and if they want to run petitions and host them, then they have to accept and understand that they can't intervene in them and take them down, even if they think some of the signatures are dodgy. That's for the council to check and decide. And we know that with elections and petitions, if it's not legitimate, then they are discounted. They're just set aside. It doesn't throw the whole process. And, if they want to say that you've committed fraud or whatever, I couldn't check my signatures, and I've got a refund for the promo that I did, the person that brought dodgy signatures. I got a refund for that, and I couldn't actually check them because of 38 Degrees. They weren't on the download sheet, all the emails, so I couldn't email them all. 38 Degrees really didn't want us all to have the emails because they knew that we'd make use of them probably in future petitions, not necessarily fraudulently, but we could actually contact those people and ask them if they'll sign further petitions, Councils probably don't like the prospect of very, very big petitions having a lot of time to have to verify and check, but when the data's there, they can verify and check it. It's a change.org and 38 Degrees has been such a terribly low standard for verification anyway in the past that it's kind of joke. But yet the local councils are like armoured fortresses, they don't want to get anyone in there. They get, local council petitions usually get from, 20, 50, 100. I've seen 6,000 or 7,000 signatures. Usually they get around maybe 2,000. If an entire village puts its efforts together, possibly 6,000 or 7,000. The hospital one got 20,000. The newspaper did a massive campaign with car window stickers and so forth. I think it did actually get enough for a referendum, that one, but they didn't have one over the hospital shutting down. They should have done. I truly believe that, if they've made it so you can actually petition for the council being completely stripped down and reformed on 5% of the signatures, then you should be able to have any referendum if you match 5% of the signatures, which in Wiltshire is 26,000 or something like that, 25,500 or 26,500 signatures. But I think that I'm certain that because it's about Stonehenge and the law says that all subjects to His Majesty's government, and it's His Majesty's government, definitely it says it on the thing in the local council, it says His Majesty's government, right? They've got to be amalgamated together. The problem is that Stonehenge is a massive subject, that there's a lot of people with a right and a privilege and an interest in that subject, and I think that is demonstrable, and it displays that they should have a referendum in it. In Wiltshire, and it shouldn't be for debate in Parliament to debunk that or take away that right when they've been vehemently redirecting 15-minute city petitions to local councils and refusing to even publish them, let alone debate them. That is the biggest insult. We should bring a legal case against the government for that. I'm going to try and get, well, this is why I'm recording this. I would like to get, at least get, someone to draft up all this down clearly, so then I can, get a local solicitor in Wiltshire to take the council to court over, that we can have a referendum. The basis for the referendum is there, the right to it is there, and that all these petitions on the same subject should be amalgamated. And really, the thing with overriding His Majesty's Government Local Council Chamber is in a local area, you are going above the council. So really, it does override. The thing with Parliament, this is the thing. If a local referendum, right, in a local council chamber, right, does that override Parliament? And Parliament will say, only a referendum to Parliament can override it, but does it override ministers' decisions in the chamber? Do they have to go by it? Well, this is the thing to do with when you're petitioning government and you're getting charged with criminal charges in connection with your proceedings being brought to the Palace of Westminster, your painting walls, promotion and so forth. Can it be heard in the local courts? Or illegal prosecutions by the King's Bench, right? Or should it be heard by committees or Parliament, right? That's the thing. That's a little bit like, with Stonehenge now. There's enough signatures, Penny Mordaunt has been sending, petitions committee's been sending 15-minute cities, redirecting them to local councils, right? There's a local council matter. That's the thing. Well, why don't they have a local referendum, which overrides the local council, right? But with a petition to government, right, you definitely are petitioning the government for the law being made or changed, which can't be decided, cognised in a court. Just like, in a criminal courtroom, you don't decide who owns land or who doesn't own land or whose house it is or whose house it isn't. And just in a civil court, you don't decide, if someone's a criminal or not. Although I think in the High Court they can. These are very similar matters. This between the petition for Wiltshire Council or to Parliament, and should they have a referendum or not, an override council, because you can still have a referendum through Parliament for the whole country, not just Wiltshire Council. But the thing is, everyone in the country is petitioning for a referendum in Wiltshire Council, only needs 26,000 signatures, whereas a petition for a referendum to local government for everyone, what's that? Do you need 3 million signatures? 5% of 60 million. You need 3 million signatures to get that. That's how I see it. And that's how I truly believe that it is. But primarily, the YouTube issue, their policy says they will comply with and apply state and federal law, but you can't really have a policy that doesn't say that. How could you have a policy that says we will not comply with state and federal law, state and federal law? It's what that law is, So, like I said in the other video, rights and private land, you have to be able to go knock. Anyone can knock on someone's door to deliver a normal letter and even have the privilege to speak to them until they tell them to leave without the right to petition. You don't need the right to petition or any protection to walk up somebody's driveway, knock on the door and speak to them, and then they can tell you to leave, right? It just says you can't be prosecuted for it, when you're petitioning. And the thing is, in a civil court, you don't prosecute people anyway, So if you were arguing whether you do have the right to put your videos on YouTube or not, that's not a criminal charge. The thing with YouTube's most severe policy, like dangerous, illegal or harmful acts, is usually if it's been breaking the law. Unless it's pretend when it's not considered as that, and that's the only reason they've got the 007 films on with extreme violence, which is because it's over 18, but it wasn't real, right? I don't know what Neil Mohan's going to do when you pretend to kiss someone. Is that sexual? Well, it's definitely a sexual act, but was it real or not? Well, it doesn't matter. You can still get sexual gratification out of it. Yes, but, most channels that break the sex policy are only getting one strike, like some of the lingerie channels and that Flexi Sex and so forth, So they're only getting one strike. So why did I get my entire channel removed when it wasn't a dangerous, violent or illegal act? And none of it was real. I haven't put one real thing on there. What wasn't from a movie, which is already on there. So, and the fact that YouTube are just lying, not that the policy's so flimsy, it's kind of flawed, because that sexual content policy really shouldn't be separated from, the movie stuff, but they have. I think it's because, it's the thing with violence is if it's pretend or real, it's illegal or not illegal, and it's either just, under or over 18. But with the sexual thing, I don't know if it's over 18, it should be able to be on there whether it's sexual anyway. So if you've got the video set to over 18, then legally you can have sexual stuff on there, right? But not, and you can have harmful and dangerous things on there as long as they weren't real, because they're all over YouTube, movie clips. So they've created this policy area where they're just being funny about it. They're trying to, if they just stuck to the law, and it's complicated enough in America with different laws anyway, they want to have their own platforms, really. They're trying to give themselves judicial authority, which is what 38 Degrees are doing now. 38 Degrees have kind of given themselves judicial authority to judge my petition, right? It's like they've given themselves, they're not judging the petition or the legitimacy of the data on there. That's for who it's to, the council, right? And that is, again, what YouTube are doing. 38 Degrees are doing that. I haven't broken a law. But when it's for petitioning, like I say, it's protected anyway. How much protection do you get? Just look through the laws now where it says if you've got a right, privilege, interest or authority. What it means is, with all those Town and Country Planning Acts, it gives you the deemed consent and authority through the enactment that you're using. And it actually creates the class and type of action and behaviour as well, like painting or so forth. And in the Highways Act, when it says, without authority, well, you have got the authority. And also in the Criminal Damage Act, it says, with a right, privilege or interest. Well, it gives you the right. It gives you the right in the Town and Country Planning Act, and it says that. So it must be the same as in the Criminal Damage Act and the other acts. And there are codified laws, like if you're in pursuit of criminals, namely going after evidence. In the Trespassing Act, if you've got a right, well, what rights are they? Well, I'm petitioning. If you have to gather some evidence, you can gather evidence for divorce cases. I've said that before, because you've got to have certain criteria to be able to get divorced, evidence of infidelities and so forth. This is what they're doing currently in the courts, is they're treating it as a defence against a criminal charge, and you're defending it, and they're making you reason, whether you should or shouldn't be doing it. They're not regarding that act of law as absolute. Like, all right, if you're doing this, if you are using this enactment, you've got the immunity. It's absolute, right? For that, and even if you were debating it, it is more of a civil court is to do with arguments around the law, arguments around rights, land and property, or what the law is or isn't. Right? I think it removes it from being a criminal charge, right? So maybe at the very least, if you're not regarded criminally, then if you're petitioning, right? But they, if they're trying to say that there should be some sort of thing, then it would at least be more like when they demolished that house in Birmingham when they didn't have planning permission and they demolished an entire building and they didn't have the permission or the right to demolish an entire building, and they don't. They did that on our local ancient site here. They built it too big, and so they were forced to demolish it. There was no criminal charge. They didn't be regarded as criminals. Maybe they should. But they just have to pay. All they do is pay fines. But big companies can afford to pay fines and get away with it, which is why you get a lot of corruption in the whole planning industry. And this is why even now big companies, when they've got enough money to buy them off when they break the law in planning, then they can even take governments to court. They're becoming, they're using these civil cases now to do what they want, mainly because they've got lawyers on their side. They've taken money off everyone else, but you're affecting our future profits. Even the government, when they're legislating, they've got megalomania. BlackRock Vanguard has got megalomania, and it's psychopathic, but not psychopathic enough, because if you are psychologically pathological enough, you can actually find the truth in the paths of psychology to prove that they are wrong and they've lied. And what about all the, they're harming the health of the people and influencing them badly? What about suing them for that rather than, suing the government for affecting future profits? They're affecting our future health. Our sperm count has dropped by 50%, since the World War II. In that video on Russell Brand with the professor woman, with the research woman, who are these? We can identify. Can we identify them? We could identify them once these big companies have bought them all up and they say, yeah, we own them all, and they're liable and responsible. There's no doubt who it is then. When it's like Mr. Johnson the butcher and Mr. Smith the baker, you can't say there's a coalition with the explicit intent to harm our health. But when all these companies are being bought up by massive companies and then they're all changing the branding, and so forth to be influential, it's very easy to identify them. The only problem is, what happens if it's King Charles who owns it? Because we can't see his paperwork, no one can see his will. When he's legal from prosecution, because he's the king, which is the ultimate irony, because to prosecute companies or company owners, prosecute them or take them to court, you've got to be able to. Now, if it's Charles, you can't, because he's meant to be the king. Now, if he were to own and buy all these companies, and if he were to be found as owning all BlackRock Vanguard, and if he were responsible for our health, would he be immune from being prosecuted for intentionally harming the health of misguiding the health of the nation and taking personal control of it or ownership? We don't know who owns BlackRock Vanguard exactly. Larry Fink is the executive, but we don't know. They're finding it hard to find out who owns it, and we don't know what's in Charles's will. So, and then it comes to the fact that are all these companies being used now as a military kind of operation? Given the fact that military have operations that are either computer or diplomatically orientated, information gathering and use, making use of such information, and using computers to intervene in information. If that's a military operation, it doesn't need to be identified with tanks, bombs, soldiers, camouflage. It doesn't need to be looked upon, or I can see that's an army because there's this jeep and there's this uniform, like non-uniform police officers, which makes you think, well, is this executive, why have they got, why are the lieutenant and the governor of the state, Arnold Schwarzenegger, and so forth? Is the whole thing military? And is this like, the Royals Enterprises in Canada when they formed, HSBC company, and then they ended up creating a country out of an executive adventure? This is the whole thing, The way they're acting now, it seems to be that through ownership of these big executive companies, they're doing what they want. Now, the thing is, if you would therefore, if there could be some ownership of these companies found in shares and so forth, which would actually give any ownership to Charles, then, well, just a minute, is this His Majesty's government and not really a private company? Even no matter how it's incorporated or formed or LLC or whatever. And if I'm trying to take the owner of these companies to court for their policy, if that's Charles, am I just petitioning Charles? And therefore, have I got the right to petition Charles on his own executive companies that he freaking owns? Ask that to Neil Mohan. So therefore, I'll ask Neil Mohan, can you tell me, Neil, who owns BlackRock Vanguard? Is it Charles or the royal family? Because then, if your owner and shareholder is the king, I've got the right to petition him about his company, and I've got my rights on his platform. But I think I've got them on anyway, because you can't form a company incorporated under the government, right, without having rights. And in fact, if you want to say that petitioning is a judicial process, right, if petitioning is a judicial process, right, like civil or criminal case, petitioning the government's a judicial process, then what are the judicial processes? One thing that really, really, really stumps me is this, right? So, you got the laws in America. If anyone commits crime, they get prosecuted, right? And civil cases are dealt with. The government decides the civil cases, who's right and who's wrong, who owns what property. Not YouTube. YouTube aren't the court, right? So disputes over land and rights or ownership is decided by courts, actually not by YouTube. It's decided by the federal government, not actually by YouTube. Staff or executives. They don't make any legal decisions at all whatsoever, right? Now, I haven't broke the law, so I'm not prosecuted by the government, right? Now, so things that I'm uploading aren't illegal. Now, this company they themselves have got immunity, so Robert F. Kennedy's saying, so if I do something which is either against policy, illegal, then they aren't liable, right? So they aren't prosecuted by the government if I put something illegal onto YouTube. But they're not taking my videos down because I did something illegal. So why would they be prosecuted by the government, right? The government wouldn't prosecute them because I haven't uploaded anything illegal. The area of their policy, which they're a private company, are saying, you can't put this or put that on there, because we say, not the government, right? They won't be prosecuted by the government for that anyway, because it's not illegal. So why do they need immunity? They don't need any immunity on an area of their policy where what I'm doing is not illegal. So they don't need immunity. Now, disputes between any party over ownership or rights, right, is not even judged by YouTube. Don't judge that either. They're not the government. The courts, the civil courts, make decisions over who's right or wrong over property or rights. Okay? And so forth. But the thing is, it's it who's judging it. It is the government. This is what YouTube don't get. YouTube don't need immunity from the law when I'm not uploading anything illegal, right? It doesn't give them immunity from me taking them to court because then they would have immunity from civil cases and all. In fact, we're the ones with the immunity from civil cases because we've already got a case. It's an existing case with proceedings, right? And we're making use out of publishing and platforms is a required function for those proceedings. You have to ask people to sign in support the case. There's a legal requirement to publish. It even says it on the government parliament website. Publish this on Facebook and YouTube. Right? But then Biden is saying take things down. Biden's apparently telling them to take things down. That's kind of like the Parliament Petitions Committee saying, publish this on Facebook and YouTube, but take that down and take that down. But just a minute, you're telling me to publish it on there, because I've got a right. So, Mohan is wrong. YouTube is wrong. These are proceedings. We're not only we're investigating things, not only are we gathering evidence of public support in a judicial process, which has got to be published in the local press or newspapers, and you've got the right to do that, and they can't be biased. I'm not in breaking. Even when you're pushing free speech and the law, but on many of these points you're not. They're trying to create their own court, which is kind of like a private one for their platform, when their platform's not entirely private because anyone can go on there or in there, right? You don't have a civil case with a shop if you don't. You don't go to court and say, argue with a shop to say I've got the right to go into it and look at shoes, right? When everyone's going in there and looking at shoes. What does that entail? There's a certain window. This is the window, right? Enter through the door. The insertion point. It's like a ship in a bottle, getting a ship in a bottle, or putting a balloon inside something and blowing it up, right? When you walk into a shop and go in there, there's certain things you can do in there, right? Like look at shoes or buy them. That's what you're meant to do. Or speak to the person next to you and say what you want. Do you like these shoes? Or should we go to the other shop and buy some, right? Free speech. You're putting a balloon inside. You can get like a toy, a doll's house, and put a balloon in it and blow it up. It'll only blow up so big, right? Now, that is to encompass your rights and liberties, right? The right to petition, being protected for doing it, comes in with that. It comes in with that. And it has to be more than simply free speech on YouTube. There is additional things to regular normal free speech or regular normal publishing and action, and this is what they are. This is a thing, right? It's kind of like saying, I've got a shoe shop, but I don't like people, so I'm not going to let them in. Well, you wouldn't sell any shoes, right? Or saying, we don't do size, it's a small shoe shop, we don't do size 12 shoes, we only do it's a children's shoe shop, right? But there are parameters, You could say it's a children's shoe shop, or you could say it's an adult shoe shop, or whatever. Those are the parameters, right? But YouTube is not saying that it is a leisure platform, only, or whatsoever. There are parameters that you can remove, and this is like when we come into the ambulance thing for medical. You can't take those medical rights away, and so forth. Really, when you are doing this petition case, collecting evidence and getting the witness, support as to sign it and so forth, it is an official judicial process, kind of like the police going about doing things, and with civil cases, there is a lots going on outside civil cases. Lawyers do most of it. You don't actually have you don't usually have an investigator or a police officer. In civil case, you have a lawyer, but you have to take things in there, receipts, that's evidence. You can get orders from the court, subpoenas, like subpoena. Those warrants that the court issue to the police, or a subpoena to say, give over this or that, the right to petition really is almost like a pre-written warrant or subpoena thing that says, look, right, they've got the right to go about the petitioning, right? Now, it's problematic when it's problematic if you've got a private house, right? If someone doesn't want you in their house, if it's not the police or emergency services, right? But it actually only says that prosecutions are illegal. So it's not, we're not going as far as to say they can't push you out of the house, but you can't be prosecuted, So therefore, is Neil Mohan and YouTube just pushing us out? But that's what they're doing with their normal policy anyway. All their area of their policy that is not illegal, the area of their policy which you're not breaking the law anyway, they're kind of pushing you out anyway, when you haven't done anything illegal. But yet, there are people reading YouTube and having access to it who aren't members, and they might be using it for petition purposes, surely the when this act is created, right, they had public houses, they had public house, a pub, they had like private houses, they had businesses, they had mills, they had companies. And I think all that would have been taken into consideration in the act when it was enacted. So I don't think it needs to be looked at in the modern codified law. And I think all the modified codified laws got to account for it and make provision for it in there, which is why you find it in the Town and Country Planning Act, like in Class F notices and so forth. The public house, right, it's privately owned. It is privately owned, a public house. They call it a public house because the public go in there, right? And, people go in there and talk openly and so forth. It's like Nigel Farage has got that programme now, when they have a pint or whatever. The basis of YouTube has got to be something more like a shop or a private house. And you've already got free speech in a pub because people, chat and yap. If someone doesn't want to talk to you, then they walk away, right? It's got to be, the principle has got to be something like, there's loads of people on YouTube, they're looking at it, they're reading it, they're logging in. You can't say, you can go into a pub, look but don't touch, you can come into my pub but don't speak to anyone, but you can listen into conversations, watch this video, buy a pint, watch the big screen, watch the match, but don't buy anything. You don't use the service, you're only coming here to take a piss. Are you only coming in here to ask people to sign petitions? Are you taking the piss? No, I'm exercising my rights, That's kind of what the position YouTube are at, really. And there's all manner of videos on there, flexi sex, movies, Daniel Craig. It's like a pub piss up, brawl, with all kinds of things going on, but then him say, no, you can't petition in here, go out, don't ask people to sign that. When there's already people, doing God knows what, It's like saying no sex in here when you go into the toilet and there's someone having sex. So why don't you ask them to leave then to the landlord? Oh, that's my wife, sir. She's like, well, you say no sex in here. Oh, that's my wife, sir. Well, she's with the man from down the road in there. How dare you? Is this a menage a trois? What's going on with YouTube and these corporate companies and the Warner Brothers and, Universal Studios with all these movies with all the violence and so forth on 18 setting, but we don't show it on here. Well, you do show it. You've got it. Well, it's, yours wasn't pretend. It was illegal. Well, get the courts then. It looks. This is the thing. What you've also got to ask the reasons for YouTube. They clearly have got films on there like Daniel Craig in these violent scenes and 18 settings. It's hardly it's not, it's not the pearly gates of heaven. I wouldn't mind if it was like, Coco Melon or some sort of children's, it's not a nursery school. So they've got, why are they, if they're showing movies on there, why are they coming up with these policies with no sex? It doesn't make sense. And then, there were political things. It doesn't make sense because they've got a contradiction. And when it's Biden, Biden wants it taken down, that's political bias and discrepancy with which the right to petition stops Parliament from saying, no, you can't petition about this subject or that subject because we don't like it or we don't want you to, or you were getting people to support it to override them with the weight of signatures and get it debated because you want it through government. Although it's been degraded so much and cast aside that the MPs don't remember why they're there, who they're representing. And this is the political... Really, these franchises, these political party takeover of Parliament, it is kind of like what's happening now with, the telecommunications, the telephone lines, telephone companies, gas and so forth. It is franchise. It's political party. A political party, but it's pretending that it's not. It's almost like trying to make out that, if they keep saying they're a business, they can get away with it. But if they start saying, we're a big corporate entity that's got royal ownership and military stuff going on, political, that's how we've come to the right place then, and we've got our rights with you, But the Petitions Committee in Parliament are doing this. The Petitions Committee in Parliament are kind of really doing what YouTube are doing, right? But they're doing it by lying, not actually. What they're doing is they're telling lies. What they're doing is you submit something and you know what it means, and then some people who signed it, you know what it means, and it is something the government can do. But they're just lying. They're just saying, we don't understand what you're asking. They know very well what we're asking. So then what you do is you submit another petition outlining exactly how it is possible for you to ask for this and the laws that you're using and which department of government it goes through and which officials in government it goes through. And this is something that I asked for. Because they're only giving you 50 characters, or 500 characters, 50 words or 500 characters, then you've exhausted all the writ of the petition, and then they say, they don't come back to you and say, no, you can't have this time. They just, a different excuse. And they don't want to, then, how can you prove this? It's vexatious, or false. Well, why would I have it? No, this is the evidence. I've attached the evidence to prove it. The woman in Newcastle, the petitions woman, is insane. They say, we don't accept links of vexatious or... no, I'm trying the information. It's almost like a judge disallowing... I don't allow any evidence in this court from off-site. It's like a judge in a court saying, no, you can't attach any evidence to these case files. We don't allow material from off-site. Just a minute. It's a case. It happened in public. It's information not known to you. It's not. In a civil case, we're arguing over the meaning of the law or the interpretation of the law or so forth. But we're talking about it's like the inventor with the new device. It's new. We need to have a judgment over it. It's yet to be decided. Or I'm trying my statement. We're trying the evidence, and to try it, it has to be in a court with a jury there and a judge, and people debate whether or not this written down is true or not. The petition committee are kind of like debating with you. Actually, with the petition, the petition is meant to secure you a debate in Parliament between MPs. But what the Petitions Committee in Parliament are doing, they are debating with you whether your material is true or not, and whether you can have it or not, and hope that they can debate it out. But your right is to have it debated, and the debate that you have is meant to be what decides whether it's true or not, right? Now, in order for that, to get that debate, they say in order for them to officially debate it, officially look into it, you got to get the 100,000 signatures, or 10,000 will give you a response. I think how they're running it now is they're kind of like doing it where, like, you know, the Martin Day and a bunch of, 10 or 11 committee members, they kind of like are, when you submit it, they're looking at it and they are kind of like acting as if they are, this is the debate, but you're not petitioning for the debate. Oh, we're going to give you one now, and you're not, you're talking a lot of bollocks, or it's lies. But, so that means that really your petition is getting looked at. Is it getting looked at or not? Is your evidence getting fully assessed or not? Do the petitions committee fully look at your evidence and assess it? And the thing is, though, if you've got a strong case that's, when you draft the subject and when you set it out, all the evidence, when you collect the signatures from the people first for the weight of support, is that contributing towards the people who agree that, and believe that the evidence and truth and fact is correct and the case, they want this? And does that therefore make it that if the petitions committee are rejecting it with 5 signatures and saying that your stuff is, they claim that it's all false, is that denying you of your debate and denying you of collecting like the weight of 100,000 signatures, which would say the contrary? Are the people who sign it kind of like the jury in a court? Because the thing is, you had a court the other day with the jury, with, Ian Bray, where the jury's decided that, apparently Greg Perrins, the judge, Gregory Perrins, said that, there's no legal basis at all whatsoever. But the jury said not guilty still. So, the jury were kind of like completely ignoring the judge, right? Is that what's happening in the referendum? Because the thing is, you're changing the law and the rules. Really, if, this is the thing, you could change the meaning of a word in the dictionary, theoretically. You could say night's day and day's night, or it at least means it. Effectively, if you're using the word day when it was night, then as long as you change the word, then, you have changed it, haven't you? Because the expression, unless you were trying to claim that, nighttime was the period of time where everybody goes to work, although by the time we've finished with immigration and all these 24-hour factories working all hours and noise at night, it might be that the case. They might be trying to do like the Truman Show with another sun rising up. There are some legal principles. If I can, reduce it down to one thing, I think that, this whole thing around, state and federal law, we will comply with state and federal law. So I think that, YouTube, they have to apply people's right to petition to their platform when they say we will comply with state and federal law. They're forfeiting part of their policy. Certain people have got immunity from it, and they're agreeing to that with the government. And the thing with petition is, it is legal proceedings. So the thing is, why would you take YouTube to a civil court if you're already engaged in proceedings with the government, who are going to judge a matter? Why? This is the thing. YouTube might not be allowed to be prosecuted for publishing other people's material criminally, but if you've got a dispute with YouTube, the thing is, the videos you're putting for the right to petition is already proper judicial official proceedings that you're engaged in, right? So to use YouTube, to publish on YouTube, and in a lot of cases there's a legal requirement to publish when it's to do with proceedings, it, in a way, by saying that, you've got to publish this and get signatures, you're being told to publish, in the newspaper, or, put notices up in public or whatever. It's almost like a pre-written warrant or subpoena in a way. It's almost subpoenaing all concerned that, they've got the right to petition on your site, basically. It's almost like a warrant or subpoena from the court to say YouTube has to let people publish on it, and it can't make a policy which would deny them, or at least, parts of the policy that aren't even illegal, because that's ridiculous. So those parts of the policy which aren't even against the law, they forfeit those by saying they will comply with the rights and liberties of the realm. And really, YouTube and these big corporate entities are subverting the laws and rights of the realm. I think the political parties have been subverting the laws and rights of the realm. So I don't even know if I can add much more into that. I've looked through the legislation clauses of YouTube, and, their policies are very vague, so you're not going to get much detail out of their policies, only criticising that there's a hell of a lot of contradiction and overlap in there when it comes to sexual activity and harmful acts, and, whether it's real or pretend, and over 18 or under 18. There's already a big cloud there, so you won't get any detail out of them on that. The rest of their policy says it will comply with state and federal law, which is the bottom line. So what is the law? So this is why I'm getting, why Velma has been helping me out with it, because what it will come down to is really what the right to petition means. What was it meant to mean, and what does it mean? I don't really think you'll find too much in the Digital Media Millennium Act, or in the Copyright Acts or so forth, or any of the other acts like the Town and Country Planning Act, which says that it's an advertisement and that you've got deemed consent. Because if it's giving you deemed consent, that's like what I said. The courts are giving you deemed consent or a warrant or subpoena to be able to go on there. YouTube, you automatically qualify for the consent. So that really should give you with the platforms, and actually, when you look at the Criminal Damage Act, it says that you're not going to get construed as a criminal charge, right, privilege and interest. And in the Highways Act, affixing signs or notices in the road, it says unless you've got right, privilege or interest. Well, we know that when it's, I'm using the right, you are using the right. The Town and Country Planning Act completely confirms the basis and what it's saying in the Criminal Damage Act and the Highways Act when it says right, privilege or interest and not to be construed against the defence against charge, because there is no charge. Now, if you're going to be arguing over, should you have been doing that or not under that right, it kind of is more of it's like a civil argument, which is kind of what happened in my case. Got a civil case got set, and like with those people with the house that got knocked down, there was no criminal charge with these big companies. If they haven't got permission to knock a house down, they just end up getting fined. It's civil actions. And so when you're using this law that says, it's illegal to be prosecuted or imprisoned, how can you be treated any less than some of these violators of, building rules and permission, Unless they're committing fraud and they lied about it and issued fraudulent statements and so forth, which never gets brought, or saying that they committed criminal damage. The police don't seem to be trying them for criminal damage, but they seem to be just letting them get off with fines. But yet they seem to be going all after the protesters, but not saying, no, we can't prosecute them, you'll have to bring civil proceedings instead, or whatever. So platforms, 38 Degrees and YouTube. Well, actually, really, maybe the 38 Degrees and YouTube argument is the same one then. The right to be on a platform and the right for it doesn't matter whether it's a video or whether it's just the actual petition. But the thing with 38 Degrees is, Neil Mohan's maybe trying to ignore petitioning or so forth. With 38 Degrees, they can't say that it's not petitioning what you're doing, and that your videos and writing and so forth aren't for a petition because it's a petitioning website. They're just saying that they've got the right to take it down when they don't, because it's proceedings, and even if they do take it down, what about all, you want it given back, or at least a copy of it, a full copy of it, so you can redraft it or something, because then you've lost all your information that you put on there if you haven't got spare copies. And that's casework. That's intervening in, government casework, really. So, I think it's kind of like one claim, really. The basis of it is for YouTube and 38 Degrees, And then there's the matter. There's the matter for the council and petitions aimed at the council or government. But the government seem to want to aim it at a council when they don't want when they claim that it's not them, and vice versa.